Wunderlich and Associates speaking.
Yeah, I was worried about it. Like, someone like this, and then they do like a big trick or something, like they'll and then you re-ask and return to say, oh, do you mean like this? I'm not really sure, and then they'll kind of like, oh, yeah. I wouldn't have to do that. Yeah, just have, because you can so blind with that. We were allowed to, like on computer. That's alright.
No, I misunderstood.
Have like a volunteer time.
Refreshing myself with the assignments.
And you can do it anytime. That was the same, yeah. Just sitting and saying it. So I always feel like that's the first. Don't waste your time. Prudence. Prudence, yes. What was that? I was having notes from my laptop this morning. Thank God.
You're warm.
Who's going to sit next to you when you're on your feet? Get someone
Yeah, well, make Derek just play part.
All's done. Coronial Court's now in session. This evening.
Dr. Dwyer.
I think we might need a few more minutes for Mr. Bowe, but there's some housekeeping to do.
Sure.
We've received a number of statements from Northern Territory Police Force. I wonder if Dr. Freckleton could provide further information about that.
Dr. Freckleton?
Yes, thank you, Erin. We've provided 4 statements and will provide a further one presently from persons in senior roles with the Territory Response Group. The essence of them is that they are very clear that there has never been an award of the kind described by the witness, and they've described, in particular by the description that he attributed to it, and they've also set out the concerns about the distress caused by the allegations made by Mr. Rolfe. I'll ask him some questions about those matters at the right time.
Thank you. Those statements have been made available to the parties?
Yes,
They
they have.
Your Honour, that raises another matter. I've read the statements. First of all, the statements make claims which are not borne out by the evidence. And indeed, the summary my learned friend, Dr. Freckleton, made of the evidence is not correct. At page 5134, my client didn't say that the award was called Coon of the Year, which was actually the Coon of the Year award. He said we knew it to be called the Coon of the Year award, but the actual award was called the Gunadar award. And what he's referring to, of course, is there's this Gunadar award, which those who got it called it the Coon of the Year award. And it was given for exhibiting the most coon-like behaviour of the year. So he
Well,
said,
the statements have addressed that. If there's additional evidence to be called on it, that could be identified. But at the moment we have 4 statements of police who are senior in the TRG or were senior in the TRG, and they have provided evidence about that. And if there's to be any additional evidence or concern about that evidence, then that's a matter that you can raise with counsel assisting if you're requesting cross-examination or something like that.
well, Your Honour, it goes wider than that. First of all, these statements are confirmation of my client's evidence given on Monday.
I'm not asking for you to explain the statements. They'll be made available. They're available to you.
Yes.
And as I understand it, I think it's appropriate in light of the evidence that they be placed on the Coronial website. But if there is to be cross-examination or other evidence led on this issue, you could identify that for counsel assisting and we'll see what arrangements can be made.
Well, Your Honour, yes, I accept all that, and that's entirely appropriate. But first of all, this evidence supports what my client said on
I'm
Monday.
not hearing submissions in relation to the evidence.
No, I'm not
If
making...
it supports your client, then that will be evident for everyone to see once they've had an opportunity to look at the statements.
Of course, but I'm just coming to my point, and that is yesterday at page 5391, my learned friend, counsel assisting, said to my client, or put to my client, in effect, an allegation that he had perjured himself. And my learned friend did it in these terms. What I'm putting to you is that you specifically nominated Meacham King as someone you had heard about, someone you had hearsay about, because you were angry that he had given evidence that didn't back you up. That was a reference to the award, to the evidence he'd given on Monday at page 5134 about Mr. Meacham King being one of the persons who could be asked for knowledge of these awards. Or sorry, this award that he referred to as the Gunadar Award, but in fact we now know, although the spelling varies between statements,
We don't know
is something to the
anything at
order
this
of
stage.
Nuguda Award. Now,
We have some evidence around these issues.
may I finish, please, my submission?
Sure,
Your Honour?
but We don't know anything. Nothing is finalised. We have some evidence on these issues.
Well, what I'm asking is that my learned friend withdraw the allegation of perjury that my client gave false evidence about the awards because, to use my learned friend's words, you specifically nominated Meacham King as someone you had hearsay about because you were angry that he'd given evidence that didn't back you up. And that's the allegation was put that my client had referred to Mr. Meacham King as one of the persons who could be approached to confirm his evidence given on Monday about what he said were the actual award was the Gunadar Award, but it was referred to colloquially as the Coon of the Year Award. So my request is that my learned friend withdraw the allegation, because these statements now back up his evidence that there was an award. As I said, he called it the Gunadar Award.
We don't need to hear the reference to the colloquial names or any other names of the award again. I understand your application, and I'll hear from Counsel Assisting.
Thank you.
It was not an allegation with respect, it was a question. And it wasn't any question putting to Mr. Rolfe that he had perjured himself. It was a question about his motivations for the first time ever nominating Mr. King. There's a non-publication order over his name at the moment, with Mr. King. Nominating that person as someone he had heard hearsay about because Mr. King had not supported him. I don't withdraw that question. For the first time ever, Mr. Rolfe was in the box nominating him with no indication that that was going to be done. And it was not put to Mr. King when he gave evidence earlier. It was procedurally problematic for that reason, and I stand by the question that was asked of Mr. Rolfe, which he's had every opportunity to answer. Might I now want to deal with the issue of the non-publication order? Because there are...
I'm not going to ask her to withdraw the question. It was a question put in examination about the evidence and motivation for the evidence that was given, and that is an entirely appropriate question to be asked, and Mr. Rolfe has given his answer.
And there's another aspect to this. We've asked for the certificates that were given out every year from 2013 onwards to 2022 at the Nuguda Awards because they are not mentioned and are not attached to these statements. There are certificates which are clearly, in my submission, racist, and we've asked for them to be produced. So they need to be attached to these 4 statements. So your Honour has a complete picture of
The
what
police
these
have
words.
investigated the matter. If they've heard that you think these statements are lacking, if they choose to provide further evidence, they can do so. There are other mechanisms for evidence to be produced to these proceedings, which would be open to you.
Thank you.
And there's to be suggested that any request has been made of Counsel Assisting, that no such request has been made, but as Your Honour says, the investigation has been...
Yes, as far as I'm aware, that's the first time the request has been raised.
It is. We received a request in writing literally a few minutes ago from Mr. Officer, and we're looking into it. And should these materials be available, we'll make them available.
Just talking about fresh materials becoming available late in the proceedings, Mr. Abbott, your client's already made reference to a letter of appreciation from an agency which we have not received or had any notice about. If there is to be additional material that you'd like tendered or taken into account, I'm asking that it be provided to Counsel Assisting by 2 p.m. today by your instructing solicitor. Otherwise, I am very concerned that we'll be at risk of not completing Mr. Rolfe's evidence tomorrow.
Thank you.
Your Honour, just one final matter on the documents. In the witness box on Monday, it was apparent that Mr. Rolfe had documents with him. I asked my learned friends to produce those documents, particularly if they're relevant in relation to the allegations that were made.
The not produced documents that he had with him on Monday, in my understanding, were instructions to his legal team which when I found out that he still had a copy of them, I have removed from him. He hasn't had them since Monday.
He had them while giving the evidence about the allegations, very serious allegations that he has made about racism. And if he had them in front of him when he was giving that evidence, then they should be produced to this court.
Well, they're not going to be produced because there's no suggestion that he was reading from them or looking at them.
He had them in front of him, Mr. Abbott. He may very well have been reading or referring to them as he looked down.
Well,
in my view, they should at least be marked for identification at this stage. I don't propose to look at them at this stage. We can raise it again later, but in my view, they should be placed in a sealed envelope and marked for identification, and there can be further discussion or legal argument about this at an appropriate time.
Well, I decline to produce them.
We'll deal with that at a later date, Your Honour. Convenient for the court to move on.
They're obviously able to be easily identified.
Yes, Your Honour. And they may well be assisted by the recording. And they could be marked for identification, and the LPP claim can be dealt with at an appropriate time. Your Honour, might I return to the issue of the non-publication order with respect to the names of those who provided statements from Northern Territory Police. There is currently a non-publication order over the names James Gray Spence, Sean Gill and Meacham King. Might I ask Dr. Freckleton to address that?
We're content for those names now to be made available for 3 persons and, of course, the additional author of a statement that's been filed with the court.
Thank you, Dr. Freckleton. Then the non-publication, the interim non-publication order in relation to those names on the statements that have been provided. And I don't think, is there any non-publication order? You said there was an additional statement coming.
There are 4 statements that have been given to the court. 3 relate to the persons subject to a non-publication order. There is a 5th statement which will be available very soon.
And that's not the subject of a non-publication order?
It is not, no.
And are you happy for that to be dealt with in the same way as these statements made available to the parties and also
Yes.
placed on the website?
Yes, thank you.
Thank you. Then the interim non-publication order is lifted in relation to the 3 names to which it applied.
May I please the court?
Mr. Bowe.
Good morning, Your Honour.
Good morning.
I hope to view that as injury time. Mr. Rolfe, may I start by taking you up or addressing the issue or the answer you gave to Dr. Dwyer as to whether or not you wished to say anything to my clients yesterday?
Yes.
Firstly, thank you for that indication. We're taking instructions, and you will appreciate that there are many members in that cohort. But may I say this, would you appreciate that sort of conversation would be a very confrontational one for some of them and difficult for some of them?
Yes.
And I'm sure it will be difficult for you. May I ask you to consider this? In terms of seeing if that sort of, if I may use the word reconciliation, may occur, you would appreciate that they have had access to many statements that you have made since the event concerning your sense of responsibility, and secondly, your directing criticism at some of them.
Yes.
I'll take you. I won't take you to it. But you know, in one of the answers that you gave to Kirsten Shorten, included, at least implied, if not direct criticism of them. Yesterday there was applications concerning the use, if any, that may be used of the evidence that you're giving about the events of 9 November. You now know that you're quite protected about that, and that protection may not well flow to a conversation happening outside. So I invite you to consider those matters when I'm taking you through the balance of our examination, and that may provide fertile ground to broker some sort of reconciliation. Do you understand?
Understood.
I want to go through some of the areas covered by Dr. Dwyer. So I'm going to do it in a way that might be expedient. That is, I'm going to generally refer to the issue. I'm not going to go back and rehearse your questions and answers. I'm proceeding on the basis that I've properly understood that evidence. I'm just going to add some additional questions. Do you understand?
Understood.
If you need further context, please ask me and I'll attempt to do that. Just one factual matter. Had you ever driven from Alice Springs out along the Tannerman Highway before the 9th of November?
I believe I'd driven halfway from Alice Springs to Yuendamu to do a vehicle swap of a person.
Okay, and did you get to Tillmouth Well?
I can't recall.
That's okay. What mobile service does your phone that you had on the 9th of November utilise?
Optus.
Optus. You're aware, did you in fact stop at Tillmouth Wells on the way on the 9th of November?
I can't recall, I don't believe so.
Okay. You know what that place is, don't you?
Yes.
It's a service station and a cafe about 80 or 90 kilometres from Yuendamu.
Yes.
You don't recall, or do you say you did not stop?
No, I say I don't recall on the night.
Okay, thank you. I want to start chronologically at the beginning in terms of, if I may phrase it this way, who you are and the context within which you had any understanding or knowledge of Indigenous people. And like I said, much of this has been covered, but you would accept that you were brought up in Canberra in relative middle-class comfort, if I can use that phrase.
Correct.
Your parents are quite respected in that local community.
Correct.
One's a lawyer in a large law firm.
She was, yes.
Yes, at the time at least.
Oh, yes, correct.
And then your father operates a Audi new car dealership of some kind.
Correct.
You mentioned your schooling. Were there any? Was it co-educational or just male?
Just male.
And were there any Indigenous students in that environment?
I'm only aware of one.
And did you have any interaction with that student?
Not a large amount.
And were there any Indigenous teachers in that environment?
I don't know.
Was any of your schooling, did it include study about Indigenous history or issues?
I believe so. Not much.
Not a great moment. Did you say?
Sorry, no, for the transcript.
At school, did you acquire any interest in pursuing further knowledge of those areas at that stage?
I don't believe so.
Up to the period of 9 November 2019, you've mentioned aspects of your interaction with Indigenous people. Did that interaction include any social interaction in an off-duty situation?
With a number of police officers, yes.
That is Indigenous police officers?
Yes, correct. And with civilians, yes.
And did you ever, in a social private capacity, go into an Indigenous person's home?
I'm sure I did, but not in a town camp or a remote community.
Did your parents provide any education to you about how you might view or learn about Indigenous culture at all?
I can't recall.
No?
I can't recall.
Now, just jumping ahead to your military circumstances. Prior to being in the ADF, had you ever discharged a firearm?
Yes, I believe I have.
In what circumstances was that, please?
Target shooting or hunting.
And at what age about, generally?
Late teens.
We've heard what you did after you left the ADF, including certain courses and the like with Orion investigations, etc.
No, Trojan,
Trojan?
and then whilst in the police force, Ronan.
Right. Is it fair to say that at that point in time, that is just before you applied to police services across Australia, that you had a particular interest and skill in using firearms?
Yes.
Just going to the applications that you made to the police service, Dr. Dwyer took you through one to Queensland, and then you had one pending in Victoria, that's correct?
Yes.
And then you also had one pending in Western Australia.
Yes, I believe so.
Now, I can get the precise date for you in a minute. Is it fair to say that you made these applications basically at the one period of time, within a few weeks of each other?
Yes, I believe so.
And the moment you got an acceptance from Northern Territory, you withdrew your application in Western Australia?
I believe so.
Do you accept, and I can take you to it if you need to, do you accept that in your application to Western Australia, there was a very similar question to the questions that you were taken to task about in terms of whether or not there were any investigations, etc., into previous issues? I'll read it to you precisely. Question 9 on that application was, have you ever been investigated by any police, law enforcement, defence force, government department, federal, state, local, or other agency, either in Australia or overseas?
Yes,
and
I accept that.
You affixed a cross to the answer no.
I accept that if that's in front of you.
You now accept that that was an incorrect answer to that question.
Correct.
Is it, what do you say to the inference to be taken about that course of events that suggested that once you had received an offer from the Northern Territory Police Force, you withdrew the Western Australian application so that there would not be any further investigation to that false entry?
I would say that's not correct.
See, you'd been told by Queensland that that was the reason why they wouldn't accept you, on the basis that it raised an ethical issue. You had the Northern Territory happen to overlook that, or not see it, or not act on it. Do you think it's a fair inference, one fair inference, that you withdrew the Western Australian application to avoid that detection?
Actually, now that you mention it, I do believe at the time that out of all the 4 applications I'd put in,
Yes.
There was a level of the Queensland, Victoria, WA seemed a more stringent process, and I believe I'd actually spoken to the NT on the phone and mentioned I'd made a mistake on my app, and they seemed not to be worried. And for your answer, correct, I believed that once I'd been made aware of my error, I believe at the time I thought that perhaps WA and Victoria, because they were being more stringent, stringent will do, that they would not accept my answer as an error.
Okay. And did you, in fact, tell them, in fact, look, I'm withdrawing it because I've made an incorrect statement in it, or did you just withdraw the application?
I don't believe I told them why, unless I think I just withdrew it.
All right. Now, at the time that you made the applications, you were working as a clerk in a law firm?
Yes.
And that was a law firm in which your mother was a partner at the time?
Yes.
And one of the referees was an employee of your mother?
Yes.
Did either of them assist you in making those applications?
No.
You didn't consult them as to how to appropriately answer questions which you may have found to be imprecise, for example?
No.
I don't think there's any suggestion he found it to be imprecise, Mr. Bowe.
Perhaps not. That's probably not a fair way to put it. I'll put it another way. The language used in the applications you understood clearly enough as being broad, and you've acknowledged that your answers were incorrect.
Correct.
Now, so when you commenced your training, is the sum total in a general sense that is that one, you had very little knowledge of Indigenous culture, correct?
Correct.
And certainly very little knowledge of Indigenous communities in Northern Territory.
Correct.
And you had very little knowledge of the history of police interaction with Indigenous people in the Northern Territory.
Correct.
And that anything that you may have been taught by the NTPF was limited to what was said in some sessions in your training.
Correct.
And details of which you have very little recollection. Is that correct?
Correct.
And it's fair to say that it wasn't a matter of great interest to you at that point.
I believe it was a matter of, I was definitely interested, but it wasn't conveyed in a obviously memorable way.
Yes. You found it not effective for you to meet your interest in those matters. Is that fair?
I found it not effective.
But aside from that, and just being candid, in truth, it wasn't a big issue relating to why you were a police officer in Northern Territory. Is that fair?
My desire to be a police officer did not have anything to do with culture or race. Yes, so yes.
Thank you. Now, it would follow from that once you hit the ground running, if I can put that phrase, you started to appreciate that in fact most of your contact with citizens in the Northern Territory as a police officer involved interaction with Indigenous people.
Correct.
And as a consequence of that, did you seek out in any forum any further information that may assist you in that interaction, or did you not think it was important?
I seeked out.
That's not fair. They're not the only alternatives.
Of course. Okay.
I think Mr. Rolfe is capable of understanding the question and giving an explanation. He's readily offered that on numerous occasions, and I don't think there was anything confusing. I don't think he believed that he was limited to the two options that were offered.
Maybe not, Your Honour, but my role is to act on his behalf, and I believe that making the objection. The learned friend, I think, would change his question.
Perhaps not Her Honour's assessment of my question. Did you understand the question? Are you happy to answer it?
I can answer it, I hope, in a way that you would be answering your question. I attempted to learn some of the language of the people I interacted, their first language. I attempted to learn some of their language to, I guess, in order to show respect, build rapport. Learning language was definitely one of the things I attempted to do. That would have been through no formal process, just speaking to them and speaking to other officers who knew the words. Insofar, that is the main area that I did. So try to learn language in order to build some form of rapport, attempt to show respect and build that comfort in speaking.
May I ask you some clarification? When you say attempted to learn the language, are you talking about their use of Aboriginal English or in fact dialect?
Dialect.
Which dialect?
At the moment, I knew more words I could put into sentences at the moment. The words I've used often that seem to create rapport or build comfort more easily. Palya and Yua for yes and please, as far as my understanding. I would use them interchangeably instead of yes and please. There were other words that I can't recall any longer, being out of the NT for 4 years. Apart from language, there was only learning through absorption through the job. for example, not through formal training at all. And even language wasn't formal training.
Understand. Did you pick up in your interaction with Indigenous people that there was often a resort to what is often called Aboriginal English?
I know what that means, but I haven't heard it in that term before.
Was that an area in which you received any particular training?
No, but I guess in regard to language as well, that was other areas where, yes, where I learned that words would mean different things. And again, these are the obvious ones that I can remember, deadly versus cheeky. But yes, if that's what is referred to as Aboriginal English.
Partly that. Did you become aware of work by anthropologists and linguists that try to assist non-Aboriginal people in communicating with Indigenous people to ensure that, because there are English words being used, that there is not, in fact, a miscommunication, for example?
No, I don't believe so.
Did you ever become aware of the work of Professor Diana Eads, E-A-D-E-S?
I don't think I've heard that name.
I provided a copy of that paper, and just on the local time. But before that's done, Ms. Wilds, can I just ask some more questions? Having got to Alice Springs, and you would have come across Indigenous people living in different circumstances and conditions than that which you were raised in Canberra.
Correct.
You've called it that the first couple of weeks was eye-opening.
Correct.
And in your interview, you said something like, well, I'll read to question 20, they're different worlds. To be honest, when I first couple of weeks in Alice, I felt more comfortable in Kabul in Afghanistan than I did in Alice.
Correct.
And you meant that reference to Kabul being when you were an ADF member undertaking military duties in Kabul.
Correct.
So can I just say this generally about that interview? I totally get that you were speaking at a time when you were facing a murder charge. You understand?
Yes.
And that you would have been using, you said things which you hoped would address the fact that you were being falsely accused of murder. Do you understand?
Correct.
And so what I'm hoping in this conversation is to get to you not feeling that pressure and just perhaps assisting us in the way in which this issue might be addressed by the NT Police Force in the future.
Understood.
And so you equated your experience as a police officer in Alice Springs, interacting with Indigenous people, as being less comfortable than the experience you had in patrolling as an ADF officer in Afghanistan.
In that regard, I believe in what I meant was that in Kabul, as I've said, that there's a one predominant culture, religion, especially in the Kabul city. There is one world, and we as ADF members were over there knowingly. That is the culture, that is the world. Whereas what I saw in Alice Springs was two worlds. You could have, like, for example, white man law versus Indigenous law and culture. I saw both, and it didn't, from my perspective at the time, there seemed to be a massive clash that was still, I guess, what's the right word?
Unresolved.
Unresolved.
Look, can I make it clear, I'm not going to try to get involved in an anthropological discussion about this. I just wanted to understand the way in which you have, in various pieces of evidence here in other documents, made reference to the living conditions in the places in which you were policing.
Yes.
And just for those hearing, I'm not suggesting for a minute that this involved all Indigenous people that live in Northern Territory or anything like that. I'm really focusing on your interaction with Indigenous people in the policing framework. Do you understand?
Yes.
And I know I'm not attempting to make a cheap point about your reference to places being shit, etc. I'm not going into that area.
Yes.
Did you form a view that the people who were living in these circumstances, which you, I think, described as third world at some points, were to blame for those circumstances? And there may be other options, I'm going to give you one, or did you consider that it may be a direct cause of the impact of white colonisation in this particular area?
I don't have enough education in history of Australia to go back to, and I admit I have not studied that topic, so I can't say that I believed it was the direct. Sorry, what was the direct cause?
Well, it's a direct consequence. I mean, there's a theory some may share that the circumstances in which Indigenous people are enduring in this country have a direct is a direct consequence of the layers of injustice caused by white colonisation.
Yeah, so I don't, as I said before, I don't have enough study in that regard to go further enough back.
Yes.
I did believe in my head it was a direct consequence as a result of the Australian government, obviously that spurned from that, but I can't go back that far.
I understand. So did you, just to return to my question, did you attribute blame to these people for the circumstances in which they were living?
I would attribute no blame, and I would attribute no fault. There is a level of responsibility in some circumstances, but definitely not blame and definitely not their fault.
But as a consequence of their conditions of living, did you take a view that that you were more sophisticated or more civilised than they were?
Well, not civilised, definitely not civilised. Depending on the explicit definition of sophistication, perhaps.
Yeah, but may I put it this way? My experience is that wealth and well-being and housing is often used by people to assess themselves against others. And then the bigger house, the better car, the better schooling for your children, denote the way in which you regard their level of sophistication and civility. You understand that?
I understand that.
And you may well have experienced that. By using that metric or perspective, did you see yourself as being more sophisticated and civilised than the people that you were seeing in these third world conditions?
Well, I can say in obviously you've mentioned my my background. I can say that potentially yes, more sophisticated, but I wouldn't classify it I wouldn't call those metrics into my definition of civilised at all.
All right, thank you. While I'm cover that, I just want to really briefly go through what I understood to be the approach you have given in your giving of evidence concerning your experience in the usage of racist words in the work environment and in private text messages.
Yes.
And can I tell you that I'm going to be fair? I'm going to be 3 or 4 propositions so that if you want to wait till I get to the end, please do so.
Yes.
You accept that you often spoke using words during the course of your work as a police officer which were racist and clearly offensive to Indigenous people. Is that fair?
No, but if I have said that, I would like to be taken to the transcript.
Yeah, in your letter, that you issued to the media whilst there was this debate about whether or not you should be giving evidence. You accept that that letter is something you wrote? You've seen it in the
Yes.
You said, I have used rude and racist terms regarding nearly every race, most often my own. I have done so in private with others with a shared background. I should not use these terms, and I am sorry for using them. When I use them, these terms in the past, they have meant nothing. Words only mean what the person using them or hearing them puts a value on them. If I were to insult you in a language you didn't understand, it would be meaningless to you. You don't get to choose what meaning someone else puts on the words to use, etc. I can keep going.
No, I accept that. Sorry, I thought we were specifically talking about something a bit more specific.
I didn't hear you.
I thought we were talking about something more specific. I accept that.
Yeah, okay. I'm putting it in that general way. You'll understand where I'm going.
Yeah.
I don't think we got an answer to your question,
sorry.
Mr. Bowe.
More alert than
So in light of that,
yes, I'll ask it again.
yes,
You accept that you often spoke using words during the course of your work as a police officer which were racist and clearly offensive to Indigenous people.
I accept that I often spoke in private in the course of my time as a police officer in racist terms. The often is due to the fact that I spoke about in racist terms about multiple races, including my own. In regard to Indigenous, I believe there's 4 messages that could be called racist by me, so I wouldn't say often in regard to Indigenous.
Right. And I can take you to the reference, but you accept that some of the words you used in that environment was clearly offensive to Indigenous people.
Yes.
You accept that some of your private messages, including to other police, also use such words.
Yes.
You say that reflected, I'm summarising completely here your reference to the TRG and your experience from sergeants, etc. You say that conduct reflected similar language being used by many other police in the station.
Yes.
Is that fair?
Yes.
And you used the phrase that the use of that language was normalised by others, including officers more senior to you.
Correct.
And the racism that you're referring to was mostly racist language about Indigenous people.
In the police station around me, yes.
Yes. You, in giving your evidence, included sergeants in that cohort. Fair?
Yes.
And you specifically excluded Sergeant Bowens and Sergeant Kirkby, and you remember the evidence you gave under examination by Dr. Dwyer.
Yes.
You mentioned to Her Honour that you had read that the use of racist terms can dehumanise people, the subject of that language.
Yes.
And is that reading a reference to the report tendered in this proceeding by Ned Dobos?
No. I would say more likely a book by the author of potentially David Grossman.
David who, sorry?
David Grossman.
And is that a separate book that you just have come across?
Years ago, yes.
So that is before the 9th of November?
Correct.
Okay, what did you understand was the thesis from that author concerning the issue that the use of racist terms can dehumanise people, the subject of that language?
I believed in that thesis or study. It was the fact that the use of racist language to dehumanise was a tool utilised by militaries in order to dehumanise the enemy, to allow soldiers who are to be more conditioned to engage the enemy, to see them as less than human.
All right. can I just unpack that a little bit about that? You knew that before you were in the ADF or after the ADF?
Potentially during.
During the ADF. And the reference to racist terms is, I think we've heard in movies, like referring to the Vietnamese as gooks.
Correct.
That is using a physical attribute, whether it be colour or their facial presentation, as a means of using derogatory terms about them.
Correct.
And the thinking being is that if you dehumanise your target, you're more likely to be able to use lethal force because you're not seeing them as equal to you. Is that fair?
Correct.
That's what you had understood. Did you happen to read Dr. Ned Douglas's report on this issue?
No, I don't recall that
You do
name.
know that it's part of the brief, do you?
Is there a title?
It's exhibit number 1029 in the brief, and it had a statutory declaration, and there's maybe a 10-page report, or 5-page report with a lot of references.
I don't think I've read that.
That's okay. May I just take you to it, and you can be shown it, because I think sometimes it's easier to read it. Then you'll see that go past the statutory declaration and go to paragraph 8.
Yes.
And for expediency, just read through quickly 8 and 9 for a moment to yourself.
Yes.
And tell me when you've sufficiently consumed that information. Perhaps even skip over that and go up the page to paragraph 11, if you can.
11.
Yes. And perhaps whilst you're doing it, so the others can keep up, Dr. Dobos wrote, in addition to making killing routine, militaries sometimes deploy rhetorical devices that dehumanise the enemy. Informally, soldiers might refer to enemy combatants as, quote, commies, unquote, or gooks or sand monkeys rather than men and women. Describing people in such derogatory terms makes it psychologically easier to kill them. You see that?
Yes.
That's aligning with what you were saying that you had read about the issue, is that right?
Yes, correct. And there's although I haven't read this, there's multiple references to David Grossman. So yes.
Global, that's the person. Well, that's
in the previous paragraphs, the first paragraph you pointed me to is I've actually read those quotes before, so I'm more aware of. I haven't read this, but I've read parts of this.
Thank you. So you understand the point that those two academics had been driving at, and that in particular, these 2 points, it makes violence more palatable by generating contempt, disgust or hatred for its targets.
Correct.
It will allow soldiers to kill and maim repeatedly without succumbing to psychological disintegration and without being overwhelmed by feelings of guilt and remorse.
Yes, I believe it. It's an attempt at that.
Yes. Now, did that, when you were being trained as an ADF soldier, was that approach taken to assist you? Because if I may say, I would find it difficult to shoot someone, to kill them. And so were you given assistance to overcome that restraint or anxiety? Not in. I believe this has been no longer utilised. Definitely not officially. There are other methodologies. Yes. But did you experience that your cohorts in the ADF did in fact use that sort of mental training to assist them? Did you hear those words being used when they're on patrol or referring to people, etc.?
Yes, we'd often call Taliban Terries.
Terries, as in terrorists?
No, as in Terry Taliban. Just like I believe in World War II, some people referred to Germans as Jerrys. It's just
and things like towel heads for the way they wear their scarves and things like that.
Yes, but my unit Terries.
Okay. So Part of Dr. Dobos's thesis, and I can take you to it if you need to, is that once a person leaves the ADF, there's a real need to demilitarise their thinking in dealing with ordinary people when they return to civilian life. You understand?
Yes.
And you'd agree with that, wouldn't you, that there's a need for there to be at least some assessment program to ensure that that training, which was absolutely necessary to be a member of the ADF, in the view of some, but would be counterproductive in engagement with ordinary people.
Yes, I can't speak for everyone that it would be necessary for the entire cohort, but it could only be a positive thing.
Were you in fact given that sort of assistance and support once you left the ADF?
No.
And would you accept that if, for example, you were returning from the ADF and was involved in, say, recreation like surfing, it may not be as critical. But if you were going to pursue a career in which many of the people that you would be dealing with would have different physical attributes, whether it be race, colour, culture, sophistication, that this becomes a critical area of focus for you.
Yes.
And did you find that many of the people that were enrolling or seeking recruitment in the NTPF did have ADF experience?
Yes, I believe there's a large percentage.
Did you intend to say earlier that whilst it may be relevant for some ex-ADF people, you did not think it was necessary for you?
Wouldn't say necessary. I understand that the use of these words can dehumanise them. In my personal, in my opinion of myself, I don't believe I was affected by that.
Now, this is leading to really the point of this area of cross-examination. Did I understand that you make a distinction between the usage of racist terms and names in language in private and even within the police station as being different from directing that language to a person that may have those attributes?
I believe there is a difference, yes.
And the distinction that you make is the former is not racist, but the latter may be racist.
If the former is conducted about all races...
Now just stick to the program. I'm talking about racist terms about Indigenous people in the police station.
If it was...
or in text messages among us.
Yes, if it was only about Indigenous people, then yes, racist.
It is racist, okay. But you say that there's more harm caused if in fact it's directed at a person that may have those attributes.
I believe so, yes.
Do you accept, however that distinction is played out intellectually, that the fact that a person in your position as a police officer uses that language, whether privately or not, even privately I should say, does say something about that person?
Yes.
See, when some of your colleagues have been taken to task, if I may use that word, about being shown racist messages or having conceded that they use racist language, they have often said, I've read that, that is not who I am. Words to that effect. Have you heard that evidence?
Yes.
Or, I have no explanation why I use that language.
Yes.
Like your friend Sergeant Holland, for example. May I suggest to you that that expression, the first one, that is not who I am, is in fact completely inaccurate because it does say something about who they are. You accept that?
That is not who I am. If you look at the person as an entirety, obviously someone is made up of lots of things.
Yes.
And you can't, I accept, for example, in my regard, in my use of racist terms and offensive terms, the way in which I speak and everything that's been seen that I've said, that is a part of who I am. I accept it's a part. So if we make that
All right.
that's a slight concession, yes, it's a part.
I was just giving you the opportunity to respond in the way in which other people have dealt with it. The fact that you yourself have used that language, does that permit some assessment to part of who you are?
Yes.
That you are, at least in part, conducted yourself in a racist fashion?
Yes.
You gave evidence on Monday when Dr. Dwyer was examining you. We traversed that issue concerning the TRG Awards Party.
Yes.
I'm just referring to that generally at the moment, and if you want me to get into specifics, I will. The general notion, if I may say, you were saying is that your explanation for you utilising that language and conducting yourself in that way was because that racist culture had been normalised within the cohorts of the Northern Territory Police Force. Is that fair?
Yes, I obviously have to take responsibility for myself, and I did it. No one made me say anything, but yes, it was normalised by the culture.
And I know you have done that. This is not what I'm getting to. You would accept, would you not, that your evidence on that issue was that there was in fact racism in the Northern Territory Police Force?
Yes.
Now, when you were interviewed by Ms. Shorten, you were asked this question.
Number?
Question 236, Your Honour. And is the Northern Territory Police Force a racist police force? And your answer was no, definitely no. There is no racism involved in the police force that I've seen. Now, I accept that the word seen might be specifically used. I suggest to you that you're actually meaning you hadn't heard of or knew of any racism in the Northern Territory Police Force.
I stand by the fact that I haven't seen a police officer acting with, showing racist behaviour on the streets, on the job. So obviously 4 years later, and with growth and knowledge about the words spoken, etc., my opinion is I am growing and learning, but I still stand by that. I don't recall ever having seen a overt behaviour that was racist, that I could tell was racist.
That's why I gave the preamble earlier, that interview should be seen in the context of when it was done and when you were at jeopardy and you were looking at ways to paint yourself in a particular way.
I agree with the first part 100%. It needs to be viewed under the point that I was under immense pressure. The end of it, I don't concede that.
Okay. What I'm saying is the question was a fairly open one. Didn't ask, had you seen anything? It was a very open one in a series of questions in which there was a lot of media agitation at the time of the shooting that this was the act of a racist cop, etc. That was the circumstances in which you were prevailing at the time of this interview. Okay?
Correct.
What I'm suggesting to you is that you gave an answer of that kind which did not seek to distinguish your perception of racism in the way in which I've sought to do so today. That's fair.
Fair.
And that you didn't explain it in any way to suggest that, look, I personally haven't seen something, but you should know about this stuff about the TRG, you should know about this. You actually gave an answer that was quite misleading on that issue. Is that fair?
That's fair, yes.
Now, having given the explanation for how you felt that it was acceptable to utilise or tolerate racist words, you don't for a minute contend that that is anything more than an explanation. It's not a justification for using that language or having that conduct.
No, not at all.
Sergeant Kirkby candidly conceded that his exposure to police work with Indigenous people was such that he formed negative views towards Indigenous people. You heard that evidence?
Yes, I recall that.
Now, when you were asked about this at question 43, the question was, now, how does your experience working in Alice impact on you personally, your perception and attitude towards the Indigenous population over the last 3 years? Answer, I know it may be hard to believe. I don't care what race anyone is. I never have and never will, and race will never affect how I police or my perception, regardless of how many jobs we attend. I don't, again, I care about people's behaviour, not their race. You accepted that, the answer you gave?
Yes.
And accepting the context that we discussed, can I just unpack that in a nuanced way, and I'll try to do it slowly. Do you accept that not taking into account an attribute of a person can sometimes be both negative and positive?
Yes.
So, for example, your view is that you don't regard a person's race in determining how you treat them, you only look at their behaviour.
Oh, okay. So, yes.
So, may I suggest to you that there's another way to approach it, that if you do not take into account an attribute, in fact, you're treating them quite unfairly. Now, expand on that? Or do you want to think about that?
No, please.
If a person is hard of hearing, and you do not take into account that they're hard of hearing in the volume you use in speaking to them, that would be treating them unfairly if you assume they heard you.
Yes.
If a person was blind, the same circumstances.
Yes.
If a person's proficiency in language was such, you could in fact be treating them unfairly.
Yes.
If a person's language is such that when they speak English, that the way you speak to them can result in a miscommunication if you don't take into account that attribute.
Yes.
So, for example, have you heard of work concerning the professor called Diana Eads at all?
I don't think so.
Yeah. Can I just give you a summary, and that may move us along? There's a notion that's accepted, I think, generally, that in questioning between police and Indigenous people who are using English, there's a concept called gratuitous concurrence.
Yes, I know what that is.
You've heard that before?
Yes.
That is, the way in which you ask a question may in fact elicit a concurrence, which is in fact not reflective of the truth of that person's response to your question.
Yes.
And you would understand that within police circles, there's been a controversy about interviewing Indigenous people with leading questions as to their involvement in an event and utilising that as an admission, for example.
Yes.
And, the phrase was often used, verbalism.
Yes.
You put things to them, you saw them, didn't you? Yeah. They did it, didn't they? That sort of line of question. You're aware of that?
Yes.
Thank you. Did you, in your attempts to properly communicate to people, Indigenous people whilst policing, take into account that concept of gratuitous concurrence?
Yes, I believe I took that. I attempted to take that into account with people of all races. I believe it can occur in all races, but it's in our training not to lead questions. I'm sure I made a number of errors in my time.
Have you experienced where police officers, knowing that, use that to the disadvantage of their person?
No, I haven't seen that occur intentionally. I don't believe I have.
Did you see it happen and then be exploited later?
I've seen it happen and lead to definitely false forms of confession. Confession, if that's enough to say, like, but not in an official interview room, for example.
It may not be how you did it, but have you seen it used as a means of shortcutting the investigation? That is, let's go talk to this fellow and see if he'll fess up to it. And then the process utilises that advantage that a police officer may have.
Oh, correct. It's occurred in this courtroom with witnesses, gratuitous concurrence, multiple times.
What, with non-Indigenous people, or?
With Indigenous witness. I've got the times in my head. I can remember and I don't know the cross-examiner.
Sure.
But I do. It has occurred in this courtroom, so there are examples of it everywhere.
Sure. Perhaps provide that to the solicitors and they can make submissions about that in due course. But and they may have the benefit of your knowledge of how that is done. Now, just go back to, and I will return to that issue in terms of how you conducted yourself on the 9th of November, but I'm just appreciating your candour and accepting that you understand that concept.
Yes.
Now I go back to it. I'm sorry to chop back and forth, but I'm trying to cherry pick through my document. The training in terms of the utilisation of force in the ADF is markedly different from the training and concepts around the utilisation of force in the police service. Is that fair?
The tactics, the weaponry used are different. When I was involved, rules of engagement have changed throughout units, throughout time. My rules of engagement, whilst I was in the service,
ADF?
In the ADF, my rules of engagement were, I would need to see them, but I would believe they were very similar, if not the exact same laws that constitute use of lethal force in Australia.
I've been imprecise. I'll go directly to the point. When you were trained to use force in the ADF, whether hand-to-hand or using weapons, that training is both physical and psychological. And I mean psychological in the sense that we've discussed about dehumanising, and physical in terms of what you seek to achieve in using lethal force, for example.
Yes, the psychological elements of it come in the physical training.
Yes.
So it's morphed together, yes.
Yeah, that's right. That's why I put it that way.
Yeah.
So you're agreeing with that?
Yes.
That is, the training is both physical and psychological.
Yes.
Now, you understood that if the situation warranted it, you shooting somebody at point blank range whilst in the ADF was lawful.
If the situation warranted, if my rules of engagement stated if my life was in danger, another soldier life or a civilian's life was in danger, I believe. I need to see it. I believe it's the yellow card. Our rules of engagement and our training stated shots to centre of scene mass as per the police force until the threat is neutralised.
No, can I just be more particular? You don't need to be realistically fearing harm or death to be a sniper and shoot somebody 300 metres away, do you?
I was never a sniper. The rules of engagement do change. I'm not trying to fight. I'm not trying to fight you.
Look, let me
My rules of engagement were very, very low level,
Okay.
so they are very similar.
Okay, so just cutting through it a bit. You knew that in a combat situation, you could kill somebody and it would be regarded as lawful.
No, it's a lot more detailed than that.
Okay, I'm not going to get into the territory of Ben Robert Smith's discussions, about whether or not a combatant was armed, whether or not. I'm not interested in that. The general philosophy of going to war with a gun is to kill people. You're using your collective force to physically overcome an opposing collective force who are armed.
I believe this question is better for a higher level ranking officer in the army.
I'll pull it back. What you did discover in becoming a member of the NTPF was that the use of lethal force is such that, quote, any use of force that is likely to cause death or serious harm, quote, must be an option of last resort.
Yes.
And that's where we've heard your evidence at various forums that you were taught various things about that concept. Yeah?
Yes.
Including the whole knife equal guns concept.
Yes.
And the shooting the scent of mass concept. And to keep shooting until the threat is incapacitated.
Yes.
Or neutralised.
Yes.
Now, you're aware that that was a primary point of persuasion utilised at your criminal trial.
Yes.
And that the phrase edged weapon equals gun or knife equals gun was deployed by your senior counsel at trial as an explanation for the way in which you conducted yourself on the 9th of November.
Yes, part of it.
And are you aware that following your acquittal, that the Commissioner of Police authorised the issue of an alert to all of the Northern Territory Police Force, which noted three things. The belief that knife equals gun is a misconception. You're aware of this alert, aren't you?
But I believe I was made aware at the time, but I'd like the refreshment of the
We don't
details.
dispute that. I'm going to read it to you quotes and others can correct me. It also noted that the phrase could have come from past training, but it has since been used, quote, incorrectly, poorly explained, or wrongfully interpreted. And the third point in the alert, operational training does not use this phrase as it bears no true resemblance to an officer's situational awareness, available tactical options, and decision-making when confronted with a weapon, including an edged weapon. Do you accept that that's the alert? That's
yes.
Part of the alert?
Yes.
In your evidence at trial, there were questions concerning of the term double tap, and I think you referred to it as a controlled pair.
Yes.
And in short compass, I think Mr. McMahon, SC, took Mr. Bowens through it, if you heard the evidence about that concept.
Yes.
Did you listen to that evidence?
Yes.
You agree, I take it, with Sergeant Bowens's responses to that examination?
No, I have an explanation. Sergeant Bowens, there's many different terms that these things could be used. I believe he said he didn't know the term controlled pair, but in fact he described in other parts of his evidence a controlled pair. So there's this similar tactic can be.
I'm not attached to the term.
Yeah.
I'm concerned to the training and the way in which that action is executed.
Oh, so that I'd need to get.
For example, my understanding is that double tap is a way of shooting at a target, which involves quick fire shooting without re-sighting the target.
Yes, double tap is a thing that, as far as I'm aware, being away from that world for a number of years, but double tap is a thing that I'm aware now is being moved away from. You take one side picture, fire the trigger, at which point the gun is naturally going to recoil and you cannot tell specifically which direction, or it's obviously going to go upwards, but specifically what direction that gun is going to recoil. And then basically as fast as you can, you pull the trigger again, not utilising the principles of the firearm principles. Therefore, the second round of the double tap, you cannot be sure of where that is going to land. So you cannot be sure of your target. Obviously, that becomes more and more problematic the further your target is away, as the distance between those rounds will enlarge.
The purpose of it is to have maximum impact to the target area. Is that fair?
I would say the purpose of it is to have a lot more impact. Maximum impact would be emptying your magazine into it.
Doubling the impact when you're comparing it to a single shot.
Yes.
Hence the term double tap.
Yes.
And what you did in those 2.6 seconds at 7:22 a.m. on the 9th of November was a double tap, wasn't it?
It wasn't, and I believe to gain further evidence more than just me speaking about it, it would or could have been easy for a firearms presentation at the range just down the road that the police obviously could have done. I believe they're firearms instructors. Now are definitely up to date with the difference between a double tap and a controlled pair. It could have been very beneficial, because this is a point of contention, for an actual physical demonstration. In lieu of that, I am sure on YouTube, for a physical demonstration, which may be better than my demonstration or my explanation, a quick YouTube search of double tap versus controlled pair may be beneficial for parties.
Mr. Rolfe, I've been misunderstood in my question. However you term it, and whatever distinction may be made in terminology, you discharged in those 2.6 seconds 2 shots without resighting, such that the bullets were likely to enter the same point.
I disagree.
Well, they did in fact enter the same point, didn't they not?
I would have to look at the images of the entry holes.
There's other evidence on that. But you were shooting at point blank range, correct?
It's been accepted that.
You accept that, don't you?
I accept that it was extremely close.
The intent behind those 2 shots on your part was to continue to shoot until you believed you had neutralised the danger.
Until the threat was incapacitated, correct.
Knowing that, given where you were pointing the gun at that time, it was likely to kill that boy.
I was following my training as per...
I didn't ask you whether or not you were following your training. I'm going as to your state of mind at that point in time. You discharged those guns, and I know you've explained it and you've been acquitted, so don't fear any consequences. Help us understand what was your intent. Your intent at that point in doing that action was to kill that young man.
Yes, and I would say I'm saying yes to your correction of calling him a young man versus a boy, which I've previously brought up as that in regard to my knowledge of Aboriginal culture. That would be extremely offensive.
Forget those sorts of distractions.
But no, I do not accept that my intent was to kill.
But you knew what you were doing was likely to kill.
I knew that was a possible outcome. Yes.
Likely outcome.
Yes.
Now, just turn to the conversation we've been having in this inquest about the immediate response team, the IRT.
Yes.
And again, I'm going to skip through much of the detail that Dr. Dwyer helped us through in your examination so far. So if you want me to go back to anything, please let me know. You accept that your interest in being a member of the IRT was something you thought would utilise the skills you believe you have in the use of firearms.
Yes, I accept that.
And as a result, at the recruitment phase and also in terms of your work in the presence of the officer in charge and senior officers, is that you were very enthusiastic about your membership of that team.
Yes, I'd accept that.
And it was a team in which you had a significant role in terms of how the team assembled, trained, and on occasions how it acted under deployment.
I would disagree with that.
Which part?
The word of significance.
Right. You had a role other than just simply being a member in the way in which training was undertaken, for example.
Sometimes I assisted.
And you had a role on occasions where you were a team leader, even though you were not allocated team leadership.
Yes, again, I don't think I would ever have been called a team leader, but leadership positions, yes.
You had conversations, and I can take you to them if you like, which suggest that you had Sergeant Boland's ear on these sorts of issues.
Correct.
You felt he would take into account what you had to say, fair?
To an extent, yes.
And you attempted to contribute in the IRT becoming a more effective part of the police service in Alice Springs.
Yes.
That included asking that a friend of yours from the ADF days could patrol with the IRT, talking about, you know who I'm talking about?
Yes.
I'm not naming. Thank you, Mr. Lamont. In circumstances where he had not in fact been through the enrolment process.
Yes.
The IRT. So your say-so of that person led to and was part of him being accepted by the OIC as being deployed as part of the IRT.
My say-so was part of it, yes, but I'd also shown Sergeant Bowens a number of incidents that that constable was involved in that were utilised for some forms of training as examples of good things. So there was one extra part, yes.
I understand. But you would accept then that on the issue of those who may be deployed with an IRT, failed to have adherence to standard operating procedures concerning the membership of and deployment of the IRT. And I'm not suggesting that this is your failing, I'm just simply saying that that is an example.
Yes.
SOP says there's a particular procedure by which senior command assess applicants for them to be able to be deployed as an IRT, correct?
Yes, correct. I think the only difference would be there is the roles in which that constable was involved in. He wasn't considered a member of IRT and it's as an attachment.
For the moment. What happened was he was deployed as part of an IRT deployment.
Yes, I believe so.
Without his involvement or recruitment being in line with the SOP. Is that fair?
I believe so, yes.
I'm not suggesting you're responsible for this. I'm just simply asking you to acknowledge that fact.
Yes.
Are you being distracted?
Yeah, but it's all good. Not it's all good.
I just had this
That's all good, I'm just watching.
Right. In fact, were you ever shown the SOP prior to 9 November 2019?
I was, yes.
And in what circumstances was you shown it?
I know I was shown it and read through it prior or during my 2-week training period. After that, I can't recall.
Okay. You've heard Sergeant Bowens' evidence on that?
Yes.
He sort of candidly accepted that it was not distributed amongst the members, and you agree with that?
Yes. Oh, because I recall that I've read it, I'm unaware if I had access to it from that moment onwards, but I know that I've read it.
Now, in simple terms, the only difference between the deployment of an IRT then the deployment of additional general duties police officers is that it was thought that the additional training would equip you to be able to provide an interim support asset in particular high-risk situations.
I believe that was sometimes the case, and sometimes it was just to provide additional general duty support with a.
That's why I put the question as I did, that the only difference is, like for example, general duties officers could be deployed to be a force multiplier for other general duties officers.
Yes.
Okay? So the IRT did do that sometimes, correct?
Yes.
But the additional feature of the IRT deployment is that they could provide cordon and control support in high-risk situations.
Yes, as an additional feature, yes.
Now, the membership of an IRT did not provide a member of an IRT to take actions any different from a general duties officer. Is that fair?
Yes, I believe so.
If the function of an IRT is to provide that extra capacity to cordon and control, what did you understand was the necessary numbers to achieve that capacity, bearing in mind some of the answers that you gave to Dr. Dwyer on this issue?
That was one of the features that IRT was capable of. All police are taught in cordons, but it depends on the specific location. A cordon requires an effective cordon requires a large number of people, depending on the location.
Let me help you. I'll summarise it. You can agree or disagree. Depending on the circumstances, 3 people might be sufficient to cordon and control a suspect. One door in a building, no other point of entry or exit. To control that person inside, you may not even need more than one, but you could have 3.
Correct, because the walls are acting
Correct.
as part of the cordon, yes.
So if you're in an open field, the numbers increase to effectively cordon control.
Yes, you need enough numbers to effectively control the entry and exit of persons into and out of that location.
So one would think, if I may suggest, that a place where there are 2 points of entry or exit, 4 might be sufficient. Leave aside windows for the moment, so 2 points of entry and exit.
If there are only 2, 4 might be enough, yes.
Now, before I get to what actually unfolded once Kumanjayi Walker was the subject of the IRT's interest, I'm going to put some propositions to you and you can comment and explain as you feel. You accept that you did not disclose to the OIC or the IRT that issues arose during the ADF service which meant that you did not become a member of the elite SAS team. Is that fair?
I did not disclose that, yes.
You did not disclose to Sergeant Bowens or otherwise discuss with him that Sergeant Vickery, Superintendent Vickery, had declined to support your application to be a member of the TRG.
I may have, but not in a formal sense.
You did not disclose to Sergeant Bowens that you were the subject of use of force investigations which had not been finalised. You did not disclose. I'm not saying whether or not they knew or not.
Yes, again, never formally.
You did not disclose the findings by Judge Borchers in relation to the Malcolm Ryder incident.
Correct.
You did not disclose to Sergeant Bowens that you had been consulting a mental health practitioner concerning some mental health issues that you were experiencing at least by the time of October 2019?
I think it was just a GP.
I think they're called mental health practitioners. But
If they are, a general practitioner, a doctor.
that doctor prescribed you with specific medication, hoping to assist you in the symptoms that you had disclosed.
Yes.
So, getting back to the question, you did not disclose to Sergeant Bones that that diagnosis had occurred and medication had been prescribed.
Correct.
Now, just going to that, and I only want to ask two additional questions concerning that medication. When you were prescribed that medication, were you told that there are potential side effects from taking that sort of medication?
Yes, I believe the GP explained some side effects, but explained that the dose was so small that it was unlikely.
So you were told of potential side effects, but with the reassurance that that which had been prescribed, if properly taken, that you should not be experiencing those side effects.
Yes, and not the full list of side effects that's listed under that drug that I'm now aware of.
You're now aware of Professor McFarlane's report concerning that.
Yes.
You're now aware that potential side effects include seeing or hearing things that others do not see or hear.
Yes.
Thoughts of harming or killing yourself or others. Overexcitement or losing touch with reality.
Yes.
You do accept that are potential side effects of the drugs that you've been prescribed.
Yes.
Did you take the medication as prescribed?
Yes.
Did it help you in any way, that medication?
Yes, it started allowing me to sleep.
And did you experience any hint of any of these side effects?
No, not at all.
You would accept that the first of those potential side effects is probably not something the person would be able to be aware of, that is, seeing or hearing things that others do not see or hear.
Yeah, correct.
So you would know if that was in fact a side effect from the medication.
Yes, it'd be very difficult to know, yes.
For example, in this case, on several instances, you have disputed what others have alleged that you must have heard, for example. Haven't you?
In regard to, I'm not disagreeing. I just need a quick.
You know what I'm talking about. You've given narratives in which you've disputed hearing something when others say that that was said, for example. I'll take him to a specific point if that's what Mr. Abbott wishes. I would like a general answer first.
Well, I object because the inference is that these statements.
Sorry, I didn't hear you. Could you address, Your Honour, what's your objection, please?
The question has it within it the suggestion that if he did, what's put to him is in fact one of the side effects that affected him.
I'll reframe
I
it
don't think he's
to
gone
remove
that far
suggestion.
yet, but I think the question needs to be clarified and put more specifically, Mr. Bowe.
Mr. Rolfe, I promise you I'm not trying to trick you. I'm just trying to get the facts of your perception. Okay? You've accepted that that potential side effect is probably something difficult for the person to detect.
Correct.
And I'm suggesting to you now that there is evidence that that may have occurred without you being aware of it. And I'll get to it specifically, Mr. Abbott.
I think you do need to go to the specifics
Thank
rather
you.
than proposing a general statement like
I'll get
that,
to
Mr.
it.
Bowe.
Yes, thank you, Ryan. You know that there is independent recording of many events that have been traversed in this inquiry,
Yes.
including from your own body-worn video.
Yes.
And there has been, some of these things have very vividly captured the language being used, and sometimes it's hard to actually hear what's being said.
Yes.
And there's been suggestions made, and I'll get to the specific one, that something was said and you have said, I didn't hear that, for example. You know what I mean?
I'm with you now, yes.
You're comfortable answering the questions then? You understand why
I believe I'm with you in the instance you're talking about.
Okay. So at the moment, all I'm trying to get you to accept is that you may well have been suffering that side effect of that medication without knowing it.
In that instance, I disagree because I've subsequently listened to the body-worn video and I still believe I heard what I heard. That's what I heard.
I've no doubt that you're going to adhere to your perceptions of what you heard. I'm not traversing that. I'm not challenging that. I'm sorry?
I'm not quite sure what the incident is that you understand.
Oh, okay, but that will be elucidated in time. Getting back to my primary point on that is that being a potential side effect, do you accept that you ought to have disclosed the fact of taking that medication to the officer in charge who was deciding whom to deploy on the 9th of November 2019?
Yes.
And that is a failing, I take it, that you regret?
Yes, I should have disclosed that.
And you did not disclose it to the others who were deployed with you?
No, I did not.
And can you see what the potential dangers of that might be?
Yes.
So you're putting others at risk, potentially, there?
Potentially, yes.
And your perception, which may have been affected by side effects, potentially put the people you were going to interact with at danger?
Yes, I don't believe they did, but yes.
Well, you wouldn't know if they did or not. That's my point.
I don't concede that.
All right, we'll get to that. Do you accept that a responsible discharge of the decision maker to deploy you needed to have that information?
Yes, I should have got a report from the GP and disclosed that.
And do you accept that had you done that, that there was a possibility, if not a likelihood, that you would not have been deployed on the 9th of November 2019?
From the advice of the GP that I received, I don't believe it was likely, it was possible.
Now what I'm saying is, if the person deploying armed IRT people into a remote Indigenous community was told that a side effect of the medication I've been prescribed and which I'm taking has these side effects, I suggest to you that you should not have been deployed.
Based off Alex McFarlane's report,
Andrew McFarlane.
Andrew McFarlane's report, yes, I would agree.
So that failing was one which was contributed to by your failing. You accept that?
But I had different information before the shooting. Based off the GP's report in regard to the extremely minor dosage, the information I was given was that there would be extremely minimum side effects. She knew I was a police officer and she believed that I would be completely fine to work in regard to my duties. She knew what they were. Based on Andrew McFarlane's report, I'm not sure if it goes into dosage, obviously leading just with those side effects with no further details about the details of the actual dosage and the information that the GP gave based off just the list of those side effects. Of course, I agree.
You accept that we will never know what impact that medication had on your conduct?
I
If any. I object.
Yes.
If
Of
any.
course, of course.
I think there could be further details in regard to exploration of the dosage, my weight, for example,
No, my point is we will never know what impact, if any, the medication you were taking impaired your conduct on the 9th of November.
Correct.
Now, may I just inquire, so I can cut out what I don't need to, how much longer would your client be willing to permit me to continue? I ask that genuinely because I
Yeah,
wouldn't
no,
cut away
I
things.
know.
Could we take the morning break? I might just take some instructions for all.
I have it
Canvass
as
it
my
right.
assessment here, but I might not be as accurate as others. Ms. Walls has an assessment.
Got a
Remember
laser
that
focus
injury
on
time, please, both of you.
it. But perhaps I could check with my little friends and then we could resolve it during the morning.
Sure, we'll take their morning tea at German and return in 15 minutes.
Thank you. Are we getting close, Sandy?
Understand? Coronial courts now issue. Please be seated.
Your Honour, may I just very briefly, so as not to take up Mr Bowes' time, but re-announce my appearance if you like, and I apologise for being absent for the last few days.
Thanks, Ms Oslands. Yes, Mr Bowe.
Mr Rolfe, you're acutely aware that I've got time limits and the council with important issues will follow. So I'm just going to be even briefer in the way I present the proposition and we can get on to it. Okay. Firstly, may I just show you a document entitled "I was a good cop, Zach Rolfe breaks his silence." You're familiar with that document?
Yes.
You accept that that is a publication in which you contributed that was published by the Australian newspaper?
Yes.
Your Honour, I tendered that document.
Yes, that would be...
Well, I'm tendering it to make it part of the evidence. I don't care with respect whether it's in the brief, I'm just tendering that document.
Sure. If it's in the brief, it's part of the evidence. If it's not, it will be given another exhibit.
It's not already in the brief, so it needs another exhibit number. I'm told it should be exhibit number 26.
Thank you.
I was asked to tender it. It's not even my document.
If the evidence doesn't make sense without it,
Sure.
then enter the
Are there additional copies of that
There are.
document? Could I get a copy, please? Thank you.
And with all due respect, my time starts now. Mr Rolfe, when you left the station at Yuendamu, that was about 7 o'clock PM that night on the 9th.
Correct.
I'm not going to cover the disagreements as to what had been said to you by Sergeant Frost and what you perceived your plan to be. But do you accept that at that point you had assumed the role of being the leader of the men with you?
Yes.
And that included the other members of the IRT and Sergeant Donaldson.
Yes.
As soon as you left the station, you went directly in your vehicle to House 577.
Yes.
That being a house identified as a potential place at which Kumanjayi Walker might be.
Yes.
You went inside that house and searched it.
Yes.
In searching that house, you did so to attempt to find him.
Yes.
And in language you have used with Kirsten Shorten, you went in blind.
I would need to read out that particular instance.
So I stand corrected. You use that phrase in relation to House 511.
Understood.
You accept that, don't you?
Yes.
I'll read it to you if you want to.
No, I understood it.
You certainly didn't go in to House 577 with any belief that Kumanjayi Walker was inside, did you?
No.
You went in on your evidence because you believed you had permission to do so.
Yes.
And you believe that you got that permission from Ethan Robertson,
Yes.
a man that was lying down on a sofa or something like that on the outside.
That's 511 again. 577, Ethan was standing up, I believe, hosing or raking.
Right, okay. But he was certainly outside the house.
Correct.
You entered the property without any permission, correct?
Entered the actual yard.
Yes.
Yes, as we were allowed to do, yes.
Well, you may or may not have been allowed to do. That allowance that you're speaking about is not due to any communication by anybody at that place.
Correct.
You are suggesting that you had implied permission to enter the yard.
Correct. Implied permission to enter the yard because we were conducting lawful duties.
In order to knock on the door, for example.
For example, yes.
So just to be clear, I'm talking about permission given to you as applied to permission you believe you had.
Yes.
You did not tell anyone within your team that you were going to enter the house to search until before you did so.
I believe I told Constable Kirstenfeld that we were going inside.
Okay, I won't go to the evidence in detail, but I suggest to you that Kirstenfeld asked you after you'd been in, did you go inside?
Kirstenfeld came in the house with me.
All right. We don't need to resolve my comprehension. In any event, excuse me, when you left House 577, you had been given some information by a 10-year-old boy there?
I believe so, yes.
And you were circumspect about the truth of what you'd been told?
Yes.
I wasn't going to use the evidence you actually gave was this. I still believed it was required of us to search the house because I don't trust the word of a 10-year-old child as actionable intelligence.
Yes.
And that's why you say you asked permission of Ethan to enter his property.
To enter his premise.
Well, this is your words, and I asked permission of Ethan to enter his property.
I accept that then.
Now, the entirety of your communications with Ethan Robertson was captured by the recording device on your body-worn video.
Correct.
And you say we need to look at it to determine whether in fact you were given permission.
The defendant clarify, object, Your Honour. We need to clarify whether no permission is needed for a police officer to enter upon premises in the course of his duties. Permission may be required to enter upon a house on a property. I argued the extent of the implied right of a police officer's right to enter 33 years ago before the High Court in the case of Plenty against Dillon. So we're not, it's a right that's been established as part of Australian law 33 years ago.
Mr. Bowe, can you just clarify precisely what you mean by permission? There's implied permission and there's, specific permission given by a person at the premises.
May I just indicate to Your Honour that long after Mr. Abbott argued that case, the High Court handed out a decision in 2020 which has made clear the law in relation to these issues, the case of Roy and O'Neill, a matter in which one of the senior counsel at the bar table, not Mr. Abbott, argued with the assistance of one of the junior counsel at the bar table. So he may be assisted in reviewing the law. I am not asking you, insofar as the entry to a person's property, you say, as I understand it, you proceeded on the basis of your entitlement as a police officer to proceed to that house because of the implied permission that is available because there is a gate and a pathway to a door or the like. Is that fair?
I agree that I entered the property due to my lawful right in regard to implied permission.
You did not receive actual permission to do that, correct? correct?
I did, yeah, correct, no verbal permission.
When you entered the house, you went in there because you believed you were given actual permission by Ethan Robertson.
Yes.
How did you determine that he was a person who could give you that permission, if at all?
He said it's his father's house. He's an adult male in the property. Front door is open. I believe that's a lawful. He struck me as a lawful occupier.
So none of the factors that you took into account involved a communication by him to you. Is that fair?
From our conversation, in addition, all the conversation that we had, all the elements involved added to my belief that he was a lawful occupier.
Excuse me. Having left 577, you were operating on further information that Kumanjayi Walker may have gone to either House 511 or 518.
Yes.
And the when you went to the fence line of 511, you had not had any communication with anyone concerning permission.
Correct.
You jumped the fence line
Yes.
without permission.
Without verbal permission, again under the implied permission.
You say now that you, in conducting your duties, had implied permission to jump the fence.
Yes.
Having jumped the house, jumped the fence, I should say. Sorry, the decision to jump the fence by you as a member of the IRT was your operational decision.
Yes.
At that point, you knew you needed actual permission to enter the house.
I did, in my view. Yes, I can't speak for Ebel, but personally, yes.
That house is in an enclosed yard with a standard height fence and a gate.
A standard what, sorry?
Standard height fence and a gate.
Yes.
You did not enter through the front gate.
Correct.
You jumped the fence at 7:18 p.m. Northern Territory time.
I accept that.
Zulu 9:48:50. You told the jury at your trial you did this because, quote, trial 1067, I didn't see a gate on my side of the fence and I didn't want to lose sight of the house.
Of that side of the wall.
Well, your words were, I didn't want to lose sight of my side of the house.
Oh, my side of the house? I didn't hear my side. Yes, correct.
Having jumped the fence, you did not walk to the front door, correct?
Correct. Correct.
Rather, you questioned random people that you encountered in the backyard.
Yes, my attention, once I jumped the
Yes
fence.
or no will be fine, we can give explanations later. And from the backyard, you had a conversation over the fence to a woman on the adjacent property.
Correct.
At that point in time, there were several people, including children, standing and sitting in the yard of 511.
Correct.
You still did not immediately go to the front door, correct?
Correct.
You didn't take any action to proceed to knocking on the door, correct?
Correct.
You did not go see if there was an occupier within that home from whom to seek permission, correct?
Correct.
The first person you spoke to was that woman I mentioned over the fence in the adjacent yard, correct?
Correct.
And do you accept, before that, you gave evidence at your trial, transcript 1068, that you had permission to enter the house, correct?
Correct. I believed I had permission.
And the permission you were speaking about was in the form of verbal authorisation rather than any implied right to enter. Is that correct?
That was, yes.
Thank you. And you say you received that from a woman who you now identify as Leanne Oldfield.
Correct.
The recordings have you using the term "hey Mrs." frequently. You accept that in that when you enter that yard?
Yes.
Why do you use that sort of term?
In my career as a police officer, that became a term that we were taught was a acceptable or even respectful term to engage with women that we didn't know their names.
Right. You say you were taught to use that title?
Yes, not officially, on the job.
So taught by your cohorts?
By cohorts, but also the people that we interact with.
I just suggest to you that some find that manner of speaking quite patronising. You may not have known that, I'm just suggesting that to you.
Well, maybe I object.
Okay, it's okay. Put it another way. If you were being now told that that sort of term may be patronising, you would hope that police would not use that sort of approach in speaking to Indigenous women.
Correct.
When you asked if they had seen Rikisha, Leanna Oldfield said, "I am not from here." Do you accept that?
Yes.
I'm trying to be precise. If we need to play it, we will. I'm trying to avoid having to play it.
Yeah, no, I'm with you.
You then said, in response to her declaration that she's not from that property, you said, "Righto, so whose house is this?" Correct?
Correct.
You would have understood at this point that she was not a lawful occupier.
No, incorrect.
So you saying that because she's present there, she might be a lawful occupant even though she was not from there.
Correct.
Were you putting in your answer that you did not believe her, that she was not from there?
No, I believe she could have been a visitor in that house.
So you accepted that she was not from there, which carries with it in interpreting that sort of conversation that she was telling you that she doesn't live there.
I believe she could have been staying there.
You didn't exclude the possibility she was staying there even though she was not from there. Is that what you're saying?
Correct.
She then told you the house belonged to Margaret, which was a reference to Margaret Brown.
I accept that.
She told you Margaret was not there, and in the video she's pointing away from the house.
Correct.
And that was a general direction to the cemetery.
I'm not aware of that, where that is.
You then, the camera turned away from her at that point. You accept that?
Yes.
And at that point, no one had spoken to give you permission to enter the house. At that point, fair?
At that point, correct.
And this is where I want to get back to two concepts And I genuinely want you to embrace those two concepts in answering these questions. The first concept is the notion that you may have been impaired in hearing everything being said to you, okay? Bearing in mind the dynamic situation that we are there.
In fairness, are you talking about impaired because of medication or
Yes.
impaired because of the dynamic situation?
I meant to make them both part of it, but yes, separately. Did you understand I was talking about the impairment from medication?
Yes, I understood.
And secondly, the dynamic situation.
Yes.
And the second concept I want you to embrace is your appreciation of gratuitous concurrence in dialogue with an obviously Indigenous woman who's speaking to you in English. Okay?
Yes.
And I know you've got a dispute about what you heard on this issue that arose at the Kumanjayi trial.
Correct.
I suggest that the recording says you asked, can we go check inside? Do you accept that?
I accept that.
And you accept that you were directing that at a person who you had not ascertained was a lawful occupier.
I don't accept that.
Her response is, go, ask yourself. And you dispute that, don't you?
Yes.
You say, it may have been said, you didn't hear it.
No, I don't say that.
Well, you'll ask this directly by Mr. Strickland, I suggest. Transcript 1157. So you asked Leanne Oldfield who you believe was the occupier if you could go inside. Question? Correct. And I think you said, whose house is that? Is that right? Answer, correct. She said, Margaret. Answer, yes. At that stage, you didn't know it was Margaret Brown. Answer, no. You said, quote, whose house is this? Margaret. And then you said, can we go check inside because we're looking for... And the question says, and did you hear her say, ask her? And you said, no. Did you accept that? You were asked if you heard her say, ask her, meaning Margaret, and you said you did not hear it.
I accept that.
Question, you didn't hear Leanne Oldfield say that? Answer, no, I didn't. That makes it clear, doesn't it?
Yes.
Just excuse me a moment.
Your Honour, I'll ask you to bring something up.
Sure.
I understand. So I'm suggesting to you that the recording shows that you asked, can we go check inside? And she said, go ask yourself. And I know you said you didn't hear that. I suggest to you that using what I would suggest is a leading question, seeking gratuitous concurrence, you then said, question, you asked a question. Go check inside.
I accept that.
And it belies the concept that you didn't hear go ask yourself when you use the same words in your question, I suggest. You said you didn't hear it, but you're actually using the words she uses and adds in there, check inside. Do you understand what I'm putting to you?
I do.
And I suggest she makes no response to you whatsoever to your leading question.
I object to that. I've got what I understand. I object to it.
What do you object to, Mr. Abbott?
What I have is what I understood, and again I stand to be corrected, is a transcript which was said to be an accurate transcript. And Miss Oldfield is recorded as saying, yeah.
Well, I'm not cross-examining on a transcript you may or may not have. I'm asking questions of this witness for his evidence.
Well, he should be played this portion then. He's being asked about what his recollection is. It's unfair. He needs to be played this part if there's some discrepancy. As I said, from my imperfect preparation, I've had to work with a transcript.
Yes.
But in fairness to the witness, it ought to be played as to what he hears or what we hear.
Given that there might be a dispute as to what he's on can be heard, I think it's fair to play that part, Mr. Bowe.
As your Honour pleases, and some more injury time, hopefully. May I seek Ms. Walters' assistance?
Absolutely.
It's the video, I think we think it's the body worn video of Mr. Rolfe, body worn video 2.
Correct.
Great.
Just so I can take up some time, whilst it's being played, Mr. Rolfe, the concept I'm asking you to comment upon, if not agree, is that the woman told you, in response to a question that you asked, can we go check inside? She responded, go ask yourself. And she was motioning to where she had suggested Margaret Brown might be. And that in response to that, I accept that you have denied hearing her say that. I'm suggesting to you that after she speaks, you say, go check inside as a question, and that there's no further response from that person.
Understood.
Can we take this forward to the second house? Okay.
Roland, you want to watch here? And I'll check here. Hey, missus. Radio check. You hear that? All good. Hey, miss. Can you come here for a sec? Can I ask you a question? Can you please come here? Please. Hey, missus, come here, please. Hey, miss, what's your name? Hey. What's your name? Rick. My name's Zach, when you in town. We're here to grab up Arnold, This house or this house? Arnold Walker.
Can we just stop for 1 second? Is there any possibility of getting greater volume?
Your Honour, there's no way I'm going to be able to answer with this volume.
Yeah, no, we need to get connected to the speakers like we did before. So what I'm told is that the audio on the live stream using the speakers will not be as good as the audio in the courtroom, but I would like it played over the loudspeaker for the courtroom. Just stop it. Stop it. Can we move the speaker closer to Mr. Rolfe?
May I
Mr.
respectfully
Bowe?
suggest we go back a bit too, please?
Sure. Mr. Bowe, would you like to come forward closer to the speaker?
Thank you for the invitation, Lauren. I prefer not to. I have listened to it many times.
All right. Does anyone else want to come closer to the speaker?
Yes,
Come forward. Mr. Abbott, maybe Mr. Hutton can allow you to sit there for a moment while we play. Oh, sure. Yes.
Hey, little one. Hey, missus. Hey, missus, where's Arthur? Are you seeing Rakesh today? Alright. Whose house is this? Can we go check inside? Go check inside? Alright.
Stop. Does that cover the area?
Yes, thank you.
Um,
I proceed at the moment to ask you some questions.
Pardon?
I'm just going to ask you some
Yes.
questions. Firstly, just going back, at no point prior to the entry did you believe you could enter that house without permission. Is that fair?
That was my belief at the time.
That's the evidence you gave at the trial.
Yes.
Transcript 1156. And you made clear from I say in your answers that at that point, with that state of mind, that I didn't have belief on reasonable grounds that Kumanjayi was in that house, I needed permission, yes.
Correct.
That was your evidence. And you asked permission from who? Enter unlawful occupant, correct?
Correct.
You say, well, for example, at this point in time, I wouldn't have legally been able to enter that house without permission, correct?
Correct.
Now, having seen that video, you accept that you... I'm doing that old person thing of losing my point. Once you jumped the fence, you did not go to the front door, correct?
Correct.
You, one person said they weren't from there, correct?
Yes.
And then you could see other people around.
Yes.
That person nominated whose house it was, correct?
Listening on that, I believe it was the now again, and obviously with my memory of this incident so long ago and all the times of the days I've been in here, I don't know if we're the same name, so I believe the other woman, ES, may have said, I'm not from here. And previously you and I were discussing as if Leanne Oldfield said that.
Sure. Okay.
That's what I am. So yeah, so the other person said, I'm not from here, not
Okay.
Leanne.
That's all right. It's respect, thank you for that. I'm not interested in that distinction at the moment. Whoever said that, neither of them were inside the house, correct?
Correct.
You did not ask them who they were, correct?
Correct.
You did not ask them why they were in the yard, correct?
Correct.
You did not ask them what their relationship was to Margaret, correct?
Correct.
You did not ask them if Margaret even knew that they were there, correct?
Correct.
And at that point in time, given that your evidence is that you're gathering intelligence, there was absolutely no urgency or any emergency that had arisen for you to enter the house at that point, correct?
There was definitely no emergency.
Nor urgency, I suggest.
I believe it was required for us to, as part of our task.
See, that's the matter of debate between you, your recollection and Sergeant Frost. She says she preferred 5 a.m. You said you were going to get intelligence. You left believing her response to your question, what if we come across him? She said, by all means, go and arrest him. That's the last information that Sergeant Frost gave you before you left, correct?
I can't recall the specific time.
Like I say, I don't want to waste my time doing that. The point I'm making is that in terms of inherent urgency, there was none. There wasn't any when you left the station, and nothing had changed to that point of that conversation, I suggest.
It depends. I believe we were just working in our duty and conducting operations as part of our tasking. So,
I understand. See, I suggest that after you asked the leading question, go, check inside, no response is given by any person in that yard to you. Do you dispute that? Did you hear anything else being said on that recording?
the recording's extremely fuzzy.
Did you hear anything else that amounted to a response to your question?
I can't hear anything apart from the fuzz.
Well, others can test that later and make submissions. The next thing you did was speak into your police communication system saying, effectively, that you and Kirstenfold were going to search inside the house, correct?
Myself and Ebel.
I object I object to that. The transcript that I have, and again, it's imperfect, says...
Well, I don't know where that transcript is from, and the question was asked about what he could hear on this recording of his body-worn video, and he's given an answer about that.
You object to Mr Abbott unwittingly giving evidence for the witness.
I'm not giving evidence.
Well, I'm not interested in what is on a transcript, what somebody else says they might have heard at a different place or a different occasion. There may be evidence of that on the brief. But what Mr Bowe is asking about is what Mr Rolfe can hear on his body-worn video.
Well, it should be put...
He did put it.
After the words go, check inside is the
No,
next thing.
sorry. Mr Bowe has said that there was no response. That's the footage.
Yes, that's right. No response from it. That's what he claims. And
Yes, and that's what he's putting to Mr Rolfe, and Mr Rolfe has answered that question.
Yes, and then we moved on to the next question, was the next thing about clearing the Red House, where I'm suggesting that...
I object to Mr Abbott reading from this transcript in a way that, please Mr Abbott, in a way that suggests answers and in effect is leading.
Yes.
I'm not leading, I'm suggesting...
All right, Mr Abbott, if you would like your client to go outside while you make this objection, I will ask him to step outside.
No, I don't ask you. Don't ask me outside.
Okay, then I won't. I am not going to hear a transcript
I'm not putting
read onto the record to suggest that Mr. Bowe has to ask his questions in a particular way. If you would like to make the objection in that way, then I'll ask Mr. Rolfe to step outside.
I'm not going to read transcript. I'm just suggesting that the premise, that the next thing that was said was clearing the Red House is not borne out. But if it is the fact, then, and the transcript I've got is wrong, then so be it.
May I continue?
Yes.
On what basis did you form the view that any of the people you were speaking to were lawful occupiers?
The persons present were comfortable in the front yard. The front door was open.
So I think that correlates with your answer at trial, 1157. They were extremely comfortable inside that property, and they were inside the property yard, the perimeter, making themselves at home. That was your answer at trial?
I accept that.
And that was the premise upon which you viewed them to be lawful occupiers, correct?
Correct.
And without being cute about this, you were extremely comfortable inside that property, I suggest, correct?
I felt comfortable doing my duty. Well,
Yes.
I wasn't making myself at home.
And you were inside the property yard,
Correct.
and the way you were conducting yourself and the way you were talking to children and hey missus, you were making yourselves quite at home, weren't you?
No.
So I suggest to you that the attributes you have sought to explain that you observed of these people that they were lawful occupiers could as easily have applied to your presence in that yard. And you were certainly not a lawful occupier. Do you accept that proposition?
That was a question and a proposition, I believe. I disagree with the... I agree with the question, I believe, and I disagree with the proposition.
The proposition is the description you gave of the basis for determining whether or not the people you were talking to were lawful occupiers. The description you gave aptly fits the description of your presence in that yard.
I disagree.
I suggest to you that Ebel said to you after your conversation with the women outside, question, so you don't know who else is in the house? And your response was, me and Adam are just gonna clear this red house. Do you accept that?
I have to listen to the body one again or be shown the transcript that the police made.
Right, so we'll let that go for now. This concept of clearing the house, transcript 1065, you were asked by your counsel, your senior counsel, have you heard the expression, quote, clearing the house, quote, answer, yes I have. What's that mean, question, answer. I think there's again been some confusion in this case as it depends on the context. There is a tactical clearance of the house where you as a team believe that you have actual intelligence that there may be a lethal offender inside, your words, lethal offender, at which point you might enter that house with your weapons drawn, you move in a tactical fashion which is taught, you clear the corners, you clear the dead space and move forward. In the context that we are talking about, it is interchangeable with the word check. We are checking that house. Right, so you were checking the house to see if, contrary to whatever you might have been told, whether Kumanjayi Walker might have been inside, correct?
Correct.
So when you said we're going to clear this house, you were operating under the belief that you could actually lawfully go and do that with guns drawn.
No.
Because really at that point in time, absent permission from a lawful occupier, you were not entitled to step inside that house, were you?
In my mindset, Yes, I can't recall Ebel's evidence.
Well, the other thing is this. In fact, Ebel was the person who first entered the house, correct?
Correct.
And you don't know, and I'm not going to bother this inquiry at the moment with the basis of his belief, but he was not a person to whom you spoke to about having permission before he entered. Is that fair?
Correct.
It has been put to you by a number of people, including Dr. Dwyer, that more senior police officers, having viewed that footage and examined the brief, disagree with your assessment that you were conducting intelligence. You understand that whole dialogue?
Yes.
As you sit here now, knowing what happened in the seconds that followed, do you accept that there is some force in their view, as expressed, that the state of knowledge you had at that point in time, even if it got to the point of being more than a suspicion that there was a belief, the right thing to do at that point, if one took into account all the matters that we've been discussing, was to step back and get assistance as to what to do next?
In hindsight, definitely things could have gone, we could have done more in hindsight.
May I just stop you for a moment? I know you're going to answer a bit more. The phrase you often have used, we could have done more or could have done better, masks an answer to the question. The question I was asking you was that it would have been appropriate to step back and get advice of what to do to have the safest course of arresting Kumanjayi Walker.
In hindsight, we could have done things differently. That option would have been, I believe, down the options I thought of, because I'd already asked for assistance from the sergeant for local members to attend and was told no.
So your response there is reliant upon your narrative on the communications with Sergeant Frost being preferred over hers, being preferred over yours. I'll reframe it. Your answer proceeds on the basis that you do not accept that she had given you the email plan, that she had not said that the reason for the 5 a.m. is that an officer familiar with Kumanjayi would then be available.
Yes, I don't accept that.
Yes. So, in stepping back from that scenario, from what you now know, and I put these things to you earlier, but just in summary, you now know that Kumanjayi Walker's uncle was an ACPO who was in the community that night.
I now know that, yes.
And that was knowledge that the forward commander had.
Yes.
And that if, once you had finished your intelligence gathering and ascertained that Kumanjayi Walker might have been inside, the safest person to approach that door to arrest him was ACPO Williams, surely.
I can't answer that.
His uncle, an Aboriginal person, a person who had safely arrested him multiple times before. Surely he was the safer person to be entering that house, and certainly much safer than you and Ubel and Kirsten Fowler.
I can't answer that question.
Surely, Mr. Rolfe, I'm sorry for my tone.
That's fine.
The point I'm making is, it's Police Activity 101 that a person in Kumanjayi's position was more likely to respond passively to somebody that was his relative, that he was well known to and who had interacted with numerous times before. This is not a criticism of you.
No, this is not a criticism.
This is a question.
I'm going to say something that you're all going to get angry at.
Please don't.
No, because I'm in line with what you're saying.
Yes.
You're saying to me, the person that Kumanjayi Walker would least likely inflict violence upon is an Aboriginal person close to him in a relationship?
No, Akpo Williams in particular.
I think if we just look at the transcript of what you just said,
No, I
if
did
we
put it that way,
repeat,
but I was...
you did put it that
Let's not have
way.
the argument. I'll put it again. You win on that, okay? The point I'm asking you is that now that we know everything we know about Akpo Williams, who was undergoing sorry business, as was Kumanjayi, who had arrested him numerous times before, who knew of his deficiencies, who knew him from being a child, surely he was the safest person to go in and get Kumanjayi Walker.
I can't answer the hypothetical, but I would have loved if Derek Williams was there to assist us.
You didn't take any steps to find out the availability of that person who the forward commander knew was there.
I made steps to ask the forward commander for local assistance. That would have included Derek Williams, who was a local officer at that station.
All right. Time's coming against me, so I just want to go through two more very short matters, if I may. I just return briefly to the Malcolm Ryder issue.
Yes.
I just want to quickly go through my summary, and again, interrupt me only if you need to. Okay. You accept that Judge Borchers made serious findings in that case about your conduct as a police officer, your credit, your honesty and integrity.
Yes.
Second, you disagreed with those findings
Yes.
and the outcome of that case. That if Malcolm Ryder was acquitted.
I accept that. Yeah.
Third, following upon that decision, you accepted information given to you by some of your police cohort that this judge had a history in his judicial conduct such that you did not respect his verdict in the case. Is that fair?
That's fair, yes.
You've chosen not to provide any of that information other than in that hearsay way that you gave evidence earlier.
In regard to
I'll get to
who?
that. He hasn't
All
chosen.
right, I'll withdraw it.
He hasn't
Withdraw
chosen.
it. I'll withdraw it. Thank you. Fourth, you also believe that the prosecution of Mr. Ryder was not adequately undertaken, correct?
I believe there were some mistakes made, yes.
Well, you commented about there being a junior police prosecutor not adequately doing the case and not putting evidence that should have been called, etc.
Yes, I believe a witness wasn't called that
You
could have
believe that
assisted.
there were shortcomings in the prosecution.
Oh, sorry, correct, yes.
Now, these beliefs entitled you to not accept the correctness of the judge's findings against you. That's what prompted you to not accept his honest finding.
Well, I was there.
Okay, that's right. The view you held about Judge Borchers was something you believe others in the station shared,
Yes.
such that his findings against you were not something that needed to be acted upon in any way.
No, I accept that I completely accept the investigation from PSC and Crime Command. That's for them to handle. I didn't believe there was any action required from me.
You are aware of, and I'll tell you what it is, but you're aware of the fact that an acquittal can be the subject of an appeal to a higher court.
Yes, within a time frame.
You had the opportunity to urge those who make decisions to appeal to review the correctness of the acquittal.
That was not my.
But you know that's available.
I know that now. Yes.
You've been in cases where you've been the complainant, the arresting officer. There's been an acquittal. You think it's an outrageous verdict. You can go and appeal. You know that.
I've never done that.
You know that you can.
I know that now.
So even though you rejected the integrity of this judge, you took no steps to seek to appeal this judge's assessment of the evidence, correct?
I think that was well above me at the time. As a young, very junior constable, I did not think that was even an option. That didn't even come to mind.
Well, you're rejecting the finding because of the identity of the judicial officer. These findings were made against your integrity, honesty. You know you can appeal this judge's determination, and the reason why you didn't accept the determination was because of the identity of this judge, correct?
I object to that question. You know you can appeal.
He hasn't conceded that he knew at the time, Mr. Bowe. It's something he knows now.
With respect, Your Honour, he said within time, yes.
In any event, Your Honour, my objection goes further because this person, my client's junior position, the notion that he has some basis where he can move the DPP to institute an appeal against a decision must surely be ridiculous.
Thank you for your evidence, Mr. Abbott. I'll just proceed with the questions on the witness. I suggest to you that the approach you've taken is that if a judge agrees with your narrative and assessment, you might respect it. But if a judge does not agree with your assessment, you will find ways to impugn that judge's integrity.
I disagree.
Now, in that sense, you accept that an acquittal is a legal construct, don't you?
Yes.
Clearly.
Clearly.
It turns on the evidence that was placed before the court, correct?
Correct.
And whatever directions the decision maker gives to themselves or to a jury, correct?
Correct.
So your acquittal is a legal construct as well, is it not?
Yes.
And you would expect that if members of my client community observed your criminal trial and heard evidence in this inquest, which was not placed before the jury in your case, are perfectly entitled to show the sort of unacceptance of that acquittal as a matter of truth.
Well, I object to this. I object to this.
Yes.
It's an improper question in my respectful submission. This type of question.
Is it going to, Mr. Bowe? I don't quite see the relevance either.
I was getting a bit excited. I was wanting to direct Mr. Roth's sense of appreciation in line with his invitation for a conversation, that he could well understand that many members of this community do not accept the correctness of the acquittal, and that informs their feelings towards Mr. Roth. But I don't need to mention.
I don't know that it's particularly relevant to the issues in the inquest.
Now, can I just go to, can I have 10 more minutes?
5.
Did you say fine, Your Honour?
5. Good hearing there, Mr.
My
Bowe.
medication's affecting what I'm choosing to hear. Let me just go to the letter that you wrote to the public. You know the document I'm talking about?
Yes.
Exhibit 26.
Thank you, Ryan. I've covered these concepts before, but this letter prompted some matters which I want to finish with in terms of the submissions that may be made. Can I just make it clear to you that it's not my project to paint you as a rogue copper, nor am I saying that the police force has in fact failed in any way in dealing with you. But there's lots of evidence that falls between those two signposts, okay? So I'm just trying to get from you as best I can your sense of acceptance of what you were communicating in that letter in circumstances where you were, at that point, taking legal steps which you're entitled to do to not come and give evidence. You understand?
Yes.
Have you got the letter with you? Yeah, no, the letter that you wrote. Is that
Exhibit 26.
Just in a different form. One, you admit to using racist words in speech and written communications, correct?
Correct.
That is in this letter. And you accept that, quote, most would find it offensive, unquote.
Correct.
You attribute that to your schooling in an all-boys school and being in the army.
Correct.
You ask the reader to, in effect, excuse this offensive behaviour because you have, on other occasions, risked your life for strangers. I read your words. Despite my language and my potential to be rude, I have risked my life for strangers multiple times, etc., etc.
Yes, I'm not asking them to excuse them because
What's the connection then of the two?
Well, above that, I say, I'm sorry for using them. The connection is, I believe, actions speak louder than words.
And I think, to be fair, you have been at pains to point out that one can be both. That one can be racist, but at the same time be quite heroic in other situations.
Yes, but I'm not saying that applies to me.
You spoke about saying that you were not aware of Kumanjayi's, or didn't take into account Kumanjayi's race, upbringing, or his past trauma.
When he was stabbing me, no.
Yes, I understand.
Yes.
Just in terms of reflection, do you accept that being aware of who Kumanjayi Walker was critical to approaching him to arrest him?
Taking away race, all the other information is definitely beneficial to, or the more information you can get prior to an arrest is always better.
Now, in that letter, and this gets a bit sensitive here, so excuse me for having to put this to you. In your letter, in particular, you say you don't see me transition from protector to medic, immediately trying to save Walker once he is no longer a threat. You don't see me call him my brother, and when he asks for my help, you don't see me and the boys do our best to save his life for over an hour. You don't see us comforting him and reassuring him as he dies, despite our team's best efforts. You wrote that?
Correct.
And I'm not for a minute suggesting that you failed to do anything that might have stopped him passing away. Okay? I'm going to suggest that you did. In fact, most of the things that you would ordinarily do were any other person. Okay? But insofar as speaking about that in this letter to seek sympathy for your position, you've listened to the body-worn videos just before he passes, haven't you? You've watched that.
I actually haven't watched the entirety.
So, when you were talking about this in the letter, you were recalling the events that were occurring whilst you were there.
Yes.
Do you recall that the ambulance officer directs the officers to perform mouth-to-mouth resuscitation?
I believe that was passed on to Hawkins.
Now, I suggest you were there when that message was coming through.
Was I on the phone?
No, you weren't on the phone, but you were there when Hawkins was on the phone.
Yes, I accept that.
And the request came and Hawkins asked, does anybody want to do it? And everybody present said no.
Correct.
And the explanation for not willing to do so is because he had been a person you had been seeking to apprehend, and for hygiene reasons.
I believe, I don't recall the first point being a reason, the hygiene reasons, and I believe at the time the police first aid training is also changed to not giving mouth-to-mouth because they believe that compressions alone will create air.
I've only got 2 minutes left. I don't want to treat this on what is the proper way to do it. What happened on that day was the ambulance officer was asking you, that is the three of you, to perform mouth-to-mouth resuscitation, correct?
Correct.
And it was declined?
Correct.
And the reasons were, I suggest, One, because he was a person you had just arrested, and two, because of issues of hygiene.
If I've said that, I'd like to be taken to the transcript.
You later ascertained, or put another way, there is evidence in fact that there were devices in the station to ensure that there was no issue of hygiene affecting those performing mouth-to-mouth. You know those sorts of devices, don't you? The hygienic devices where you can apply mouth-to-mouth without physical contact.
I know that. I've heard that was that is found, but I'm not aware.
You didn't ask for one. Nobody asked for one.
We asked for all the first aid kits in the
at
station.
At that point in time when you're being asked to perform mouth-to-mouth, you did not ask for it.
Correct. I believe there was none there.
You could hear Kumanjayi Walker calling out several times at that point, correct?
Yeah, correct. He spoke throughout the whole 60 minutes before he passed out, I believe.
You're aware that when you left 511 and came to the station, that there were many members of the community that had seen and heard him being shot, correct?
Correct.
And in fact, you went to the station about some fear of payback of some kind.
We went to the station because there was no point us going to the clinic, which was locked. It was the only other place to go.
You could have performed attempts to resuscitate at the scene.
That wouldn't have been safe.
That's what I said, because you were concerned that there may be some form of payback at that point, or some response violently towards you.
For a number of reasons, I don't believe that would have been appropriate.
Right. The point I'm making is you knew that by the time you got to the station, there were family members likely to be outside.
By the time we got there,
Yeah.
or soon after?
Or soon after.
Correct.
This young man was dying at that point, correct?
Correct.
You knew he was dying.
Correct.
In fact, the other person that's got military experience said, basically, you get shot there, you're not going to live.
I don't agree with that.
All right,
with the stuff that we had, yes, I knew it was most likely there was a very small chance of survival.
He was calling out for his mother, wasn't he?
Again, I'd have to get taken, but I accept it. If it's on the body-worn video, I accept that.
And you thought your comfort would be sufficient to meet his need and request for comfort from his family.
That did not, that was not in my mind at all. The option of allowing his family into the station never passed my mind. So in lieu of that, all I did was provide him the highest level of comfort that I could provide.
My point is, you were spruiking your humanity in your letter to the media by pointing to how you conducted yourself, but this teenager's request for the support of his mother as he was dying was refused. You accept that?
I thought I was waiting for a question. I was waiting for a question. Can you please say it again?
I was asking whether you accept that that was hardly a humane response to his situation at that point.
I disagree. I believe that our response was extremely humane.
Thank you.
Thank you, Mr. Bowe.
Thank you, Honour.
Just before we come to you, Mr. Mullins, there's just one housekeeping issue.
There is, Rona, before we go further with the next counsel, and just in the event that it is relevant to other counsels' questioning, I renew my application for the documents that were brought into the witness box by Mr. Rolfe on Monday. If there is a further refusal by Mr. Abbott, KC, to produce those documents, then I will ask or invite you, Honour, to issue a summons pursuant to Section 41 of the Coroners Act, Northern Territory. If there is a legal objection to the production of the documents that were in the witness box on Monday, then it should be made, in my respectful submission, with supporting evidence, and Your Honour can make a ruling after reading any relevant affidavits, etc., on production.
Can we just start with the renewed call for the documents? Can they be produced on the understanding they'll be in a sealed envelope on the basis that there might be some further legal argument about it.
Your Honour, I'm instructed that to maintain the claim for legal professional privilege in respect of the documents, I don't want to be in contempt or in breach of any ruling you make. This is a sensitive matter. I haven't had time to fully explore and get full instructions. It's not a matter that can be dealt with on the run, and I will need some further time. I would suggest at least the lunch and adjournment before we come back to this issue, and I may need until tomorrow morning.
Dr. Dwyer?
Well, it might be appropriate for my learned friend to give that further consideration, and I could have a discussion with him after the lunch and adjournment and see where he's up to in that stage.
Yes.
I'm happy to have such a discussion with my friend.
Mr. Mullins, sorry.
Thank you, Your Honour. Mr. Rolfe, my name is Mullins. I act for the Brown family who raised Kumanjayi. They have some questions for you. Now, I know there's lots of documents that are involved in this case, and if you feel in any way that you need to look at a document or you want to look at a transcript, please ask.
Yes.
And I'll make sure that you get a copy of that. May the witness start with Exhibit 20-73, please. And this is a copy of your interview with Kristen Shorten from The Australian. Do you have a copy of that handy? I'm happy enough for it to be on the screen. I'm happy enough for it to be just handed to him. The last thing I want to do is upset the system. So if it being handed to him is sufficient, I'm happy with that. It's page 26. And for the benefit of the people on the live screen, I'll read it, the passage that I want you to address into the record. But if you want to read the answer at 140 at the top, you probably should read the question on the page before as well.
Is it possible to put it on the screen without causing issues? Have we resolved that problem or not? Do we know?
It's meant to have been resolved.
Answer 140, A140. Yeah.
If you could just read the question, Mr. Mullins, and then the answers on the next page, put the answer on the screen.
So the question at 140 on page 25 of Exhibit 20-73 is describe what you can hear and everything that was happening at that time. Was there a lot of screaming commotion? Had other people come into the room? And this is after the shooting.
Yes.
That's right. And we're at house 511?
Yes.
And that's the question that's being asked. And you answer this way. As soon as shots were fired, I could hear the screaming and the wailing from family outside. And in saying that, your family outside at the time had told us that, yes, he was in the house. If they'd even offered to go inside and pull them, bring Walker out themselves, I would have given them my handcuffs. They could have done it themselves if they had told us the truth. But they didn't tell us that he was inside. We went in blind. And you agree that they're the words that you told Kristen Shorten on the 5th of December 2019?
Yes, I do.
Have you ever, I withdraw that, had you provided your handcuffs to a family member to take them inside and to handcuff Kumanjayi, they would have had to have walked from where you were after you gave them the handcuffs, gone out of sight inside the house, applied the handcuffs to him for some unspecified period of time, and then walked back out with Kumanjayi handcuffed. Is that right?
Correct.
Have you ever done that before?
No, there was never been a situation where it was required.
Under what circumstances are you allowed to hand a piece of police equipment? I should say, is that part of your accoutrements?
Yes.
Under what circumstances are you allowed to give your accoutrements to a member of the public to go off into an unseen place and to handcuff a person?
Obviously, that's not part of training. It is something I would have been willing to do.
Is it in accordance with the operations manual that was operative at the time?
That part is not, no.
All right. It's nonsense, isn't it? You would never have given your handcuffs to a layperson to take into a house out of sight to handcuff somebody and bring them back out.
I would.
You would do that?
I'd be happy to.
No. You see, what you're trying to do here is to somehow suggest that the family had some responsibility for what happened inside House 511.
I agree, yes.
And in doing that, you knew at the time that you performed this interview that they had facilitated an arrangement for Kumanjayi to be handed over.
I wasn't aware of that information from Sergeant Frost.
No, but you were aware of that by 5 December 2019, were you?
No, I hadn't received any evidence.
Okay, so you had no idea, as at 5 December, some 1 month after these events, that there had been an arrangement with the family to hand Kumanjayi over the following morning?
Correct. It was months before we got the brief of evidence, and then the brief of evidence, I believe, ended up being in approximately 50,000 pages. So...
wasn't that in the email on the phone that you received?
That was the email on the phone. I had this might be a fix for some people's minds. I had my personal phone. I did not have a work phone. I had no access to work emails on my personal phone. So, for example, previously I was asked about the service station on the Wells. Even if I had reception there, I wouldn't have received the work email. I could have received a work email on my iPad if I had it. Obviously, I didn't have that after I was arrested. So I did not have access to that email until it was part of the brief.
You gave your evidence yesterday that you went out into the community on this afternoon to engage, introduce yourselves to the community and gather intelligence. And there was a fourth matter that I didn't write down. Can you remember what that was?
Seek their assistance, I believe.
Seek their assistance, all right.
Or cooperation.
Now, did you think it was a problem that when you got out of the vehicle at House 577 and House 511, that 2 of the 4 people that were seeking to engage, introduce themselves, gather intelligence and seek assistance had long-arm firearms?
It was taken into consideration. I didn't consider it a problem.
Do you think that people might be frightened by police officers with long-arm firearms? Did that ever occur to you?
On the individual situation.
Do you know the Warlpiri people's history with guns?
I know about obviously through only what's been talked about in this Coronial.
Well, at the relevant time, did you know anything about Warlpiri history in relation to guns?
I can't recall.
Did you know at the time anything about the Coniston Station massacre of 1928?
I can't recall when I learned about the Coniston massacre.
If you did know about that, you would be hesitant to go marching into a community with 2 of the 4 members carrying long-arm firearms, because that's going to turn people off immediately, isn't it?
I do not have a large enough understanding of intergenerational trauma to answer these questions to a proper standard.
In any case, why would you think the family of the person who was in that house would provide police officers with assistance in bringing him out in circumstances where they didn't know you from a bar of soap, and where you have just arrived carrying long-arm firearms.
Why did I think they would provide
Why would you think they would assist you in bringing the person out of the house and handing them over to you?
I would say I wouldn't make the assumption that they would. It's a hope that they would, but I don't automatically assume that they would.
So when you suggested in this interview with Ms. Shorten that the family were, to some extent, responsible for not assisting to bring him out, do you think that was justified?
No, the responsibility I was placing on them was the fact that they did not tell us, and I know this is a incredibly hard time for the family to hear, and ideally they probably wouldn't like this answer, but I am here telling the truth. There is a responsibility that is to be bared by not telling us that Kumanjayi Walker was inside that house. And I accept that is hurtful, but this is about the truth, and that's the truth from my perspective.
Like, that's your perspective?
Yes.
Is that a convenient time, Your Honour, or...?
Yes, we'll resume at 1:30.